Good morning.
Morning, Judge.
Okay, I have five positions on the calendar this morning. I'm going to run through and get announcements on them real quickly. Also want to give you a heads up that I also need at about 9:30, maybe 9:45, depending on when the parties are ready. I'm going to need to take a break for about 20 minutes to go take a criminal plea, and then I'll come back and finish up whatever we're doing. But some of this I think we can address fairly quickly, and some of it we'll need to spend a little bit more time with. So let's go ahead and get started with the announcements. So I have Vianta Yancey versus Arletha Maddox. Who do I have here on behalf of the plaintiffs in that case?
Russell Hodges on behalf of the plaintiff, Your Honor, and we are ready.
Thank you, sir. And who do I have on behalf of the defendant, Arletha Maddox?
Alonzo Nelson, good morning, Your Honor.
Hi. And this is down for a pretrial conference, sort of a status check-in because the case keeps getting set for trial, and I know there are other issues.
Okay. There was an issue that has been resolved.
Okay.
We have on the 19th of August, the caveator to the petition for administration withdrew her caveat. And so the court has informed me at 5:12 p.m. yesterday when I said, "Where's my letters?" They said within 48 hours, we will receive letters of administration. So we should be ready to go forward with our case
Okay.
on the 25th for trial.
Okay. Mr. Nelson?
Well, Your Honor, I don't think there's anything left to try, but we can, because this case is one the court has already granted partial summary judgment.
Right, but that was only as to one property, and there's that other property that's out there. And obviously, I'm aware that Mr. Hodges disagrees with that partial summary judgment, but it does still leave that one property out there to be dealt with. Is the probate court dealt with it in some way? I can't imagine.
That property was foreclosed on by the lender and is no longer available to the estate.
Okay.
So there's nothing relating to that piece of property that I could see that the court would be able to do since the lender has taken it back.
Okay, well, I'll tell you what.
Your Honor, I might point this out. The summary judgment was granted against Mr. Yancey in his individual capacity regarding his tortious interference claim, not against the administrator of the estate. The administrator of the estate was not subject to any of the reasons for the summary judgment. That's why we wanted to go ahead and get appointed. When we filed this, we said pending administrator,
Right.
and we've been fighting over being the administrator. So now we actually are. So that property that still exists is very much in play.
Okay.
Through the administrator's claims.
Hang on, forgive me. So let me say that sounds like fertile ground for us to discuss in our pretrial conference this morning. So I'm going to take some time and plow through to figure out what the issues are. But it sounds like we're going to need to spend a little time doing that. So if you guys will sit tight with me for a few minutes, I'm going to come back to you and we'll see if perhaps an updated pretrial order or something like that will help us narrow those issues and figure out what we're going to actually try in late September. Okay, so I'm going to call the rest of my calendar and come back to you guys. American Express versus Zanaya Blake.
Christopher Dewan.
Excuse me. Scott Peskin for the plaintiff.
Okay.
Christopher Dewan for the defendant, Your Honor.
Okay, and I think I just this morning received a consolidated pretrial order on this matter.
That's correct, Your Honor. I apologize for the timing. We've just been missing each other for the pretrial conference the last 2 weeks.
Okay.
I believe that we're still waiting on discovery. I think Mr. Peskin can talk to that. We have no issue with that. I think we just need some time to get discovery and a little more time to work something out. We just need a little more time, basically, Your Honor.
Okay.
As plaintiff, I agree with that. This came up real fast, and
well, due respect, gentlemen, the reason it came up real fast is because it got filed, it got served, the defendant filed an answer, and then the court told the lawyers, I'm going to enter a scheduling order if y'all don't tell me what order y'all want. And y'all didn't tell me. So I entered a scheduling order that said, this is what's about to happen. And then it would be set for trial. So that doesn't mean you can't convince me to do otherwise. But the reason it came up quickly is because y'all didn't take the opportunity that you were invited to take several months ago to say, hey, this is a unique credit card collection case that for some reason requires substantial discovery prior to the bench trial. Just saying. So I do have your CPTO. We'll work through that here in just a few minutes and figure out how much time y'all need and what we might do with it. Damon Garcia versus Department of Driver Services.
Good morning, Judge. Attorney Golden on behalf of Mr. Garcia. We're ready to go forward on that. I know that respondent did file a motion to dismiss, so that will have to be heard prior to the actual petition.
That's correct. Ms. Radley?
Good morning, Your Honor. Amy Radley on behalf of the Department of Driver Services. Even with that motion to dismiss, both are pure legal argument. I can't see my side taking more than 10 minutes, 12 minutes in total.
Okay, Ms. Golding, how about you?
I think about the same for that.
Okay, so 30-ish minutes, we'll call it.
Yes, Judge.
Okay. Ventura Management versus Latanya Holmes.
Good morning, Your Honor. Brendan Parnell on behalf of Ventura Management. We're ready. We're here this morning on our petition for review from a matter in the magistrate court where a default judgment was entered, and we had filed a motion to set that aside. It was denied. We were not given notice of the hearing. We can get into the specifics, but we're ready to go.
Okay, and about how long do you think that will take to present?
5 or 10 minutes if we are just presenting the argument on the petition for review of the order from the magistrate court. If we're de novo trying the magistrate court case, then that's a different story.
Understood. Ms. Holmes?
Good morning, Your Honor.
Good morning, ma'am.
I'm Latanya Holmes, and this is my fiance, Mr. Gilmore, who's been with me through this entire ordeal.
Okay, thank you. So Ms. Holmes, you heard Mr. Parnell. So there's sort of two issues that the court needs to address. One of them is the procedural issue of whether the case is appropriately before the court, which I understand you take issue with. And then separately, if the court were to decide that the case was allowed to be in front of the court and that the court should hear the substantive issue, then there would be a discussion about the nature and a de novo review, which means the entire case would be subject to the court's review on the issues that were actually decided by the magistrate court. I don't want to condescend to you, but I also want to make sure that you understand that what we're talking about in terms of it being sort of two different things.
So essentially, you're saying that the earlier court ruling is being decided here in terms of whether it's even admissible in the first place.
So yes and no. So the issue is that if the first decision I have to make is whether or not Ventura Management's petition is appropriate in this court, right? Whether it's allowed to be heard here.
Yes, ma'am.
And if I decide it's not allowed to be heard here, then I would dismiss it.
Yes,
Yes,
ma'am.
ma'am.
If I decide that it is allowed to be heard here, then I would actually hear all of the evidence of what the parties are actually disputing about. And so
Yes.
I just want to make sure you're aware that's two different things. And we need to take up that preliminary issue of whether the case is appropriately before the court first.
Yes, ma'am.
And so if we were just to address that issue, Mr. Parnell has indicated he thinks it would take about 5 or 10 minutes just to talk about the procedural issue. How long do you think it might take you just to talk about that aspect of the procedural part of the case? The service issues and whether there was a default judgment and that sort of
Oh,
thing.
Judge, it's cut and dry for us. Yes,
Okay.
it's cut and
So
dry.
sounds like pretty brief then?
Yes, ma'am.
Okay, thank you.
You're welcome.
Okay, and then last question to everyone. I don't know if I see a court reporter here. Did anyone request a court reporter, and is anybody requested? Because my court reporter is not available for civil takedown, so. Okay.
No on behalf of Ventura Management.
Okay, well, hearing no one popped up when given the opportunity, then let's keep plowing ahead. I will say that plea hearing that I'm supposed to take up is set to start at about 9:30, but sometimes it's a little late because we got to make sure everybody's in all the right places. So we're going to just plow ahead. What I would start with, you always get penalized for having the longer arguments. If I'm going to start with a couple that I think are relatively straightforward, Mr. Peskin, and Mr. Dewan. So what is it that the parties actually need to accomplish? I mean, I'm hearing discovery, but you also heard me say, I mean, at the end of the day, this is a credit card collection case. So tell me what it is that y'all need to accomplish and why I should extend this trial, move it to a later date so that y'all can accomplish those things and be ready. Obviously, I would love for y'all to resolve this through a consent order, if that's what might be enabled by an extension. But let me start with Mr. Dewan. Tell me what it is y'all need to accomplish, Mr. Dewan.
Yeah, I think there was just miscommunication. I know that Ms. Peskin talked to it. We split discovery, and with all these cases, we have to receive discovery before we can do anything. And I think it got lost in the weeds. Until I spoke with him, we weren't really sure what was going on. We had good discussions yesterday about getting me the documents I needed and possibly resolving the case. It's just between reviewing the documents, talking to my client, and also him going back to his client. I just don't think, I think 2 weeks will be enough time to do all that, with my schedule being I'm going to be on a number of court calendars in the next 2 weeks. We just think that an extra month will resolve it without having to bring the court into it. I've resolved several cases with Mr. Peskin over the last 15 years, and I'm pretty sure we can work this one out, Your Honor.
Okay, Mr. Peskin?
Well, I would concur with that. Regarding the discovery, it never got to us. We have no record of receiving it. And there has been a long time problem with the Odyssey using an address for me that's at least 2 law firms ago. And we've been, we've tried. Fulton County says it's the Odyssey. Odyssey says it's Fulton County. And it's just something we've been having to deal with. And I don't, some things we just don't get. But I'm glad to give Mr. Dewan the discovery he needs. It just never got to our office. But I also concur that we have resolved many cases over the years. Even just the next month, October's calendar might just be enough time to get this taken care of.
Okay. So Mr. Peskin, you definitely need to get that issue fixed, because I routinely have it happen. So for example, today's hearing, I mean, you're here, so it doesn't matter, but all of my hearings are essentially peremptory, and all of my hearing notices say that if you don't appear, then I can dismiss the case or take whatever action. The reason I mention that is that frequently what happens is we get set up for our hearing, somebody's not here, and we go into the system and we are able to look and see if the party ever opened the notice that the court sent. And so it's obviously very important that y'all are reliably able to receive the notices that the court sends, because we are allowed to send them through Odyssey, and we're allowed to rely and expect that they were received by a responsible person who could, either be the lawyer or make the lawyer aware of it. So, given the fact that ultimately this will likely result in either a fairly short and straightforward bench trial or a consent order, a consent judgment, I will let y'all have a one-time pass to move it to the October calendar. Just so y'all know, what that means is it will be moved to the October calendar, which I think is the last week of October, but it would be called in again for a pretrial conference on probably the first week of October. So, if y'all are, given that it is a bench trial, if y'all don't think that that's necessary when it gets noticed, y'all can say, hey, do we need to appear? We've already submitted our CPTO. It's a bench trial. Let us work on it and we'll appear when you call us in. That's fine. Y'all just need to stay in touch and let us know. Otherwise, I will see you guys either when I get a proposed consent judgment, or I'll see you guys for trial at the last week of October. Okay?
Thank you, Your Honor. May I ask one question?
Yes, sir.
If in fact we aren't able to get something worked out and it shows up for trial, would it be possible for a witness to appear through Zoom
So
My
I'm a
witness-
big fan of Zoom, but I believe as a matter of courtesy, as well as I think the rules, so long as the parties consent. But generally speaking, for not all of my bench trials, but for some of these fairly straightforward bench trials that might last an hour or two, I will frequently do the whole trial on Zoom, unless anybody has a strong objection. So why don't you guys talk about that and then let me know if y'all are able to agree. And if you are able to agree, then we'll get a Zoom set up and we'll conduct the whole trial by Zoom if that's what the parties are inclined to do. And even if we conduct the trial in person, I still have the capability in the courtroom to have a witness appear. We do it frequently on a big board. And so that's fine with me as long as the parties agree. If the parties don't agree, I still reserve the right to allow it. But I would need to hear argument from the both sides about why it would be necessary and why the parties can't agree. Okay?
Yes, Your Honor. Thank you.
Thank you.
Thank you. Have you excused, Your Honor?
Yes, sir. Thank you both. Have a good day.
Thank you, Your Honor.
Okay. Mr. Hodges and Mr. Nelson. So Mr. Hodges, talk me a little bit through, I certainly understand the basic premise that you've raised, that the administrator of the estate of Ernestine Ford is a separate entity than Vianti Yancey, and that might change the effect of what the court has already ruled on. But I need you to talk me through a little bit more about the specifics of what you're referring to in terms of the issues that are still pending for trial. You're muted, Mr. Hodges.
Apologize. We have one house and two issues. The other house unfortunately got foreclosed upon. The house is there. You grant a summary judgment against Mr. Yancey. You could not grant a summary judgment against the administrator since there was no administrator. So, Your Honor, the order does not apply to the administrator. Now we are the administrator. Also, res judicata or whatever it was, I forget. It doesn't apply to the administrator because he was not the one being evicted from that house. The administrator had nothing to do with it. So it's our position that the administrator may proceed on this one remaining house. And we have two issues. One is a tortious interference issue by Mr. Yancey, which may be moot with Your Honor's ruling. If there's only one house and you rule against me on summary, which leaves the 23-260 motion for setting aside the deed because of fraud. And that motion is very much alive. And we claim that it was done in fraud.
Okay. And because, now forgive me, probate, definitely not my strong suit. But because the caveat has been withdrawn, there's no, originally there was some discussion that with the caveat pending, that it would be the obligation of the probate court to resolve these issues associated with the claims of fraud to determine where the asset would go in the estate, to what heir. But now that caveat has been withdrawn, is that no longer an issue before the probate court?
Well, it's the position of the defendant that the house is not an asset of the estate at all.
Okay.
It was transferred prior to the death of the decedent. And since being transferred prior to the death of the decedent, right now it's not properly before the probate court.
Understood. Okay. Mr. Nelson, I obviously am very aware that I granted summary judgment on the one of the properties that is still existing on the basis that I'm trying to recall, but basically the issue was that it's the subject of litigation in the magistrate court regarding a dispossessory. Is that right?
That is correct.
Compulsory counterclaim.
Okay, thank you. Thank you for refreshing my memory. Mr. Nelson, what say you regarding the fact that the estate still has a right to, now that it has an administrator, pursue issues associated with the fraudulent deed at a minimum?
The administrator has no greater right than the heir himself. And even if Mr. Yancey, and since Mr. Yancey is the heir and he lost his right to pursue this claim by not filing it as a compulsory counterclaim, the administrator is in privity with him and cannot now turn around and sue for the same thing that the heir lost his right to do in magistrate court. Therefore, this court cannot go grant the administrator an order setting aside this deed, since the heir has lost that right. It's gone. The administrator can't refresh and renew it, and therefore, the judge, your order granting partial summary judgment as to the Old Spanish Trail House disposes of that issue, and it's no longer there. The administrator has no place to go with it. He's lost it, and he's barred from pursuing it. The res judicata doesn't apply.
So,
I heard go ahead.
I'm sorry. Go ahead, Mr. Hodges.
I've heard anything but a citation of law. It sounds like Your Honor needs briefs on this. What I would suggest.
That's exactly what I was about.
Is that we go ahead and set it for trial, and we submit briefs in advance, and you can even give it a deadline if you want for briefs. I don't mind that.
So one of the matters I was looking at is, I agree with you, and I was about to say I'm going to need legal briefing on this issue. I'm also wanted to ask y'all's opinion. So obviously the original complaint, should it proceed, contained in it a demand for a trial by a 12-person jury. If the claims that we are assuming claims survive and the claims are related to equitable revision of a deed, although the underlying factual basis for that would be a finding of fraud, is it the plaintiff's position that you would still be entitled to a jury trial on that issue because of the underlying factual nature of the finding that would need to be made before the court could make an equitable or legal determination as to its effect on the deed?
Appreciate Your Honor's query, and that should be part of the brief also.
Okay. Okay. So here's what I would like to do. So this, as I said, this matter is set down for the week I'm sorry. For the week of the 25th, I'm trying to pull up my calendar and talk at the same time, and I apologize. So what I need to know is whether for scheduling purposes, I need to know, we have to decide whether there's going to be a jury or not. So what I may end up needing to do is, put y'all on a pretty tight schedule to see if we're going to get to the week of the 23rd. I think the actual jury day would be the 24th of September. It is the 5th today. Can y'all have briefing to me by Friday of next week, which is the 13th of September? I'm not looking for a legal treatise. I'm looking for fairly straightforward addressing of two issues. One is the extent to which the changed position of Vayonta Yancey, no longer being individual Vayonta Yancey, but now being the administrator of the estate of Ernestine Ford. One, that res judicata, et cetera, would not apply. The basis of the summary judgment motion that the court granted would somehow not apply to foreclose a further claim. And if it did, the extent to which, if what's left for the estate is an equitable remedy, is there still an entitlement to a jury? Given that the ultimate remedy here would be legal or equitable remedy granted by the court. And it may be that we decide that the parties agree not to have a jury. It may be that the parties decide that you need a jury to find the facts of the alleged deed transfers that were allegedly fraudulent or forgeries. And then depending on the outcome of that finding by the jury, the court would then act upon the legal or equitable remedy that flowed from those findings of fact. But those are the issues that I need. I'm really looking at, I don't need a legal treatise. I really, really cannot communicate enough how much I don't need a legal treatise. So, I mean, I'm very familiar with res judicata. I'm very familiar with, I mean, to me, it seems like the issue is the extent to which the parties are actually in privity and had the same interests and or had the same right to vindicate or protect or pursue a remedy, that counterclaim that allegedly was not raised, right, in the magistrate court, given that the state didn't yet have an administrator. So anyway, that's what I need y'all to focus on. I'd like to limit y'all to 20 pages apiece. And because I am doing it on such a tight schedule, if upon receiving each other's, right, orders or motions on the 13th, that'll give you a little bit of wiggle room if one of y'all needs to reply to something. Very limited that you did not already raise or address, but specifically needs to reply to something that's in each other's briefing. You could do that no later than the 18th of September.
Okay.
So September 13th for briefing on those two issues and September 18th for a reply. Now, the extent to which y'all decide that either you want to forego a jury or you don't think you would be entitled to a jury, let me know that sooner rather than later, because again, that's going to control the scheduling of when I have a jury available to me, or we can sort of schedule it at our leisure if it's just in front of me. Whether setting aside that it would take a half a day to pick a jury, how long do you think it would take to present this case, Mr. Hodges?
Any jury trial to me is two days. It will not be 3 days.
Okay. Mr. Nelson, does that seem reasonable or?
It does. I only have a few witnesses that.
I was just going to say, I mean, it seems like most of the witnesses are going to be Mr. Yancey and Ms. Maddox. And maybe a few other people that can talk a little bit about those circumstances, but okay, so I'll put down 2 to 3 days conservatively, and we'll go from there. Anything else that y'all need or want from me, Mr. Hodges or Mr. Nelson, before we adjourn? And I look forward to receiving y'all's briefing on the 13th.
Ma'am, I appreciate your parameters. I understand them, and we'll comply by the 13th.
Mr. Nelson?
The only caveat I have is I'm on 2 other trial calendars, but I'll do
well, and that's why I want to know where I want to get a lay of the land of what we feel like is legally there, because it may be that the week of the 24th is not good for anybody, and we can try and push it to the next week or the week after. There's a little bit of maneuvering that I have the ability to do. I just need to see how much maneuvering I need to do in terms of, do I need a jury or is it just going to be us? But I think you should assume that the trial is going to happen in relatively short order, whether it happens on the 24th of September or a week or 2 weeks later. It will happen. It will happen unless y'all resolve.
Your Honor's got at least 2 weeks.
Yes, sir.
Okay.
Yes, sir.
I understand.
Okay. Thank you both.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day. Okay. And then Ms. Golding and Ms. Radley, please forgive me, but I'm going to take up the other matter. And so you guys are going to be last because I think we're going to spend the most time. Because I suspect, Mr. Parnell and Ms. Holmes, that what I will do today is address the procedure. And obviously it could be dispositive, or if it is not dispositive, then we'll see how ready we are to plow through the substance of the underlying case. So let me start with this. Mr. Parnell, I was able to review the docket and the filing. And so what I often like to do is start with, here's what I think I know about the case, and then you can tell me what else I need to know or correct me if I'm wrong about something that matters to you.
Sure.
Into your case. So what I think I understand, and honestly, this was a little confusing to me, is that initially Ventura brought this action in magistrate court. And that is where it got off track, because it seems like Ventura was in the case. This was an odd case procedurally, but ultimately where I think it all ended up is Ventura's position has always been, if I'm not mistaken, that it was not served. I have looked, I've intentionally tried not to look at too much of the meat of what's there, but I have looked at the service affidavit, and I think I understand your client's position, Mr. Parnell, to be that the service affidavit is deficient on its face because it doesn't actually say that it was personally served on anybody or give any. It says it was served, but the address you take issue with, and then the actual circumstances of the service are not identified or provided in that service affidavit. And from there, I'm going to let you take it, because again, I was a little confused about the procedural posture of the case and how it started.
Sure. And I will correct the court and try to clarify what's happened procedurally. There have been 2 magistrate cases. So Ms. Holmes filed the first case, which was sent up to Superior Court. That's the statement of claim that was filed on 3/29/23.
Okay.
And that is the magistrate court case. That's 23 MS 180744. And that is the case that we are challenging. In that case, a default judgment was entered against Ventura Management. And that is the one to which we contend that we never received notice, were never properly served, and therefore the default judgment, a hearing was had of which we were unaware, and a default judgment was entered in favor of Ms. Holmes and against Ventura. Subsequent to all of that, Ventura filed a separate dispossessory action and action on the lease in magistrate court against Ms. Holmes for unpaid rent. And in that case, Ventura got a judgment against Ms. Holmes.
Okay.
Now, that case has not been petitioned up to this court, and that case is not before the court.
Right. But I think, if I remember correctly, that is one of the things that Ms. Holmes filed a notice requesting that the court take judicial notice or filed into the record, and that the court be aware of that case's docket history.
I would agree that she has filed that, and that she would like the court to take judicial notice. Our position on that is that that judgment, the judgment in favor of Ventura for unpaid rent against Ms. Holmes, is not before the court for reconsideration, right? Because an appeal or a petition was not filed timely or properly with the Superior Court.
Understood.
Okay, so that's where I think that's where the confusion lies, in that there were 2 landlord-tenant related magistrate court matters. Each one resulted in a default judgment for the other. So I would agree that it's been a bit procedurally irregular. But we are here today on Ventura's petition to the Superior Court for review of the magistrate court's really it's their order, denying our motion to set aside the judgment. And so as it relates to that, you are correct in that it's Ventura's position that service was never proper in the first instance in that case, because there's an address issue. Also, it wasn't served on anyone with authority. Ventura is not even aware of the individual upon whom it was purportedly served. It states that it was served on, it says.
Well, isn't that part of the problem? I mean, it doesn't actually say, right? If I recall correctly.
Right, right.
It says it was served on Ventura Management on May the 1st at 9 a.m. But then there's nothing checked indicating the manner of service, personal, substituted, etc.
That's right. So we think it's improper on its face. It says under other AA, I assume that's African American, male refused to accept document.
Right.
Quote, Ventura Management is not accepting civil suit. Ventura, the affidavit that was filed in conjunction with the motion indicates that there's no one that fits that description. We're unaware of who that would be, but certainly on the affidavit on its face, nothing's been checked, and they didn't appear because they weren't aware.
Now, is that one thing I was a little confused about? I mean, I know that part of your position is that that's not the address of the registered agent for service, whose address is a totally different address. But is that not the address of Ventura Management's principal office, the Desert Drive Building 2?
So I have noted when the case came to me and I looked at it and I noticed that the principal office address with the registered agent, with the Secretary of State differs from the address stated in the affidavit of service. I will note or concede to the court that the address on the lease is the North Desert Drive address, and my client can testify to that further if need be. But I think the main issue is that service was purportedly perfected upon someone without authority, whom we don't know, but certainly someone without authority to accept service, in that it wasn't an officer, a manager, a managing agent, etc.
Okay. So given that there is in the record at least facial, might be a little inadequate, but at least facial evidence of service on an individual at the service address, or at a physical address that is associated with the company. Are you not obligated to provide sort of more substantive evidence or documentation demonstrating why service was not sufficient, or other than just, we don't know who that is? And I'm not suggesting that I'm right, or that that's dispositive of the outcome, but I do think procedurally, when there's at least facial evidence of service, there is a burden on the party contesting service to come forth with evidence demonstrating that there in fact was not service.
Sure. I think I don't disagree with the court there. However, I do believe that in conjunction with the motion that we filed to set aside, we provided testimonial evidence in the form of the affidavit of Mr. Tabar, indicating that there is no person that we're aware of that could be, right? Then that the company did not authorize anyone to refuse service. So I would say yes, when there is some facial evidence of service, there is a burden on the defendant to refute that service. But I do think that has been done, and I also think that facially the affidavit of service itself has some defects.
Well, I agree with you that the affidavit of service leaves much to be desired in terms of it effectively demonstrating service in the way that the court would want, and in the way that a party who is trying to secure service would want.
And another thing I might add, the plaintiff in this case or any case is the master of service. I mean, they dictate to whom they're going to serve, particularly when they have and hire a private process server, they instruct the private process server how they want service made. And that we do it all the time where, and I'm sure this court is aware, when a private process server is hired, the instructions can be serve at this address, make sure you get a name, make sure you get authorization, document everything that you do to ensure that if we come before the court on this service issue, we've got what we need. And I don't believe that is the case here. The best way to do it is serve the registered agent. And then you're going to have good service. And they didn't do so here. Not saying, the law allows service on more than the registered agent. So I'm not saying that that's the only method, but certainly it would be a preferred method and avoids situations like this where you have some unauthorized individual making statements, refusing service, etc.
Okay. Okay. From a procedural perspective, can you walk me? So I've reviewed the docket, and because I do not mean this, because of the volume of what the magistrate court is dealing with in these kinds of cases, I know that they don't often have the ability to give me a lengthy, detailed, recitation of the history of the case, but I still need a little bit of clarification. So I understand that this matter was filed, it was set for hearing, and no one appeared in approximately sometime in September, and a default judgment was entered in September. And then it appears to me that sometime in November is when Ventura became aware of it, filed a motion and an affidavit to set aside the judgment. But then where I get a little confused is it appears that it was set for hearing and then nobody from Ventura showed up. And so that motion was denied again. The motion to set aside was denied. What happened there?
Well, I'm not sure what happened there, but at that point, I was attorney of record. I was in the case. We never received a notice of hearing. My client never received a notice of hearing. We were waiting because there was an order entered that said, clerk, set this down at the first available calendar. And apparently that happened. But as an officer of the court, I can state in my place, I never received notice. I'm not going to miss a hearing. And my client didn't either. So I don't really know. And importantly, I think on that issue is in the record that was sent up from the magistrate court, there is no notice of hearing of that December 6th hearing that we apparently missed.
There's an order to set the hearing.
Correct.
But that is a direction to the clerk of court to note it, and then it looks like, let me see, I'm trying to see what I can see in my system. So in my system, there's a notice that's generated, a Zoom notice that's generated, but it's not, it's because I'm not, it doesn't carry with it. So in my system on the 6th of December, there is an entry that says motions calendar. And when I click on that, it indicates that there were 3 scanned images on November the 22nd, which appear to be notices of hearing. That were addressed to Joseph Enfield L., who I believe was Ms. Holmes's attorney at the time. And then hang on. And then one addressed to Ventura Management LLC, 3485 North Desert Drive, Building 2, Suite 101, East Point, Georgia, 30344. And last but not least, one addressed individually to Latanya Holmes. Now, I don't, nothing about this form indicates that it went anywhere, but I don't know that that means it did or didn't.
Well, at that point, Your Honor, I would say I was in the case and of
Right, you
record,
had filed an entry at that point.
and I didn't receive that Zoom notice.
Okay. Okay. So thank you, Mr. Parnell, for walking me through that. Ms.
Sure.
Holmes?
Yes, ma'am.
I'd like to hear from you. And remember, as we were talking, I'm trying to focus right now on that procedural part before we actually get to whatever the substance of the case is about, because I have intentionally not educated myself necessarily about what the actual relief you're seeking is or the circumstances of it.
Yes,
But if you can address a little bit about the notice issues that I've been talking about and the service issues, that would be very helpful to me.
yes, ma'am.
Hey, Your Honor, how are you?
I'm
So-
doing fine. So let me interrupt for a moment. Just so you forgive me, Ms. Holmes, I know you introduced me and that he is your fiance, but I did not catch his name.
Yes, I'm DeWitt Gilmore.
Mr. Gilmore. The reason I ask is, Mr. Gilmore, are you an attorney?
No, ma'am, I'm with her. We are partnered in the property. So we're
Okay. No,
yeah.
no.
I'm actually the person who was going through all of the hiring of the process server, dealing with the property management along with Latanya. So
Okay.
there's things that I know, things that she knows, and together
Okay,
we're a team.
That's all fine. Here, the reason I'm asking
Mhm.
is that generally, so in magistrate court, right, you can represent yourself and it's a little less formal. In Superior Court, technically, an individual can only represent themselves, and only Ms. Holmes is currently a party. Now, I'm guessing that Mr. Parnell will probably be, I mean, he has the right to object, but at this point, I'm okay with it being a little informal, but I do want to let you know, Mr. Gilmore, technically, it sounds like you are a witness with probably important information about the substance of the underlying case. But for purposes of the procedure, it's technically Ms. Holmes's case. And if you're not a lawyer, you're not supposed to be representing another person or acting as their agent in the court. So Mr. Parnell, any concerns about that? I'm okay with being a little informal, but I just wanted to make that cautionary to Mr. Gilmore.
Yeah, I mean, I agree with the court, and I will, the court wants to hear what it wants to hear. So, I'm not going to try to step on that, but I agree at this stage, Mr. Gilmore is a witness. So if we get into evidence, then certainly he can testify.
Of course, yes.
To the extent we're talking about argument on a procedural issue, it should be Ms. Holmes.
Okay. Well, I appreciate that, Mr. Parnell. I just sort of wanted to make sure that we were all on the same page in terms of Mr. Gilmore. Again, I don't doubt that you have relevant information that I need to hear, but I just wanted to make sure I'm happy at this stage right now, informally, to hear from you. But to the extent that you're going to be offering evidence about that underlying substance, we need to hold off on that, because that would be an issue of you being a witness, and that carries with it different circumstances. So with that caveat, please, Ms. Holmes, however you're going to present, what is your response?
My response, Your Honor, is that I legally did hire Eugene Young. He is a processor. Them saying, also, I want to add that at that point, there has been nothing during that season, if you will, that states that Mr. Parnell was the attorney then. To say that they don't, for Ventura Management or whomever told Mr. Parnell that they don't know who the African-American gentleman was, I can tell you it was a gentleman who worked for them named Nelson M. Kenji, and they called him Jackson. How do I know that? It's because with all the issues that were had, He's the one they kept sending to the property that I met with, Mr. Gilmore met with. And there's on text message, he's on my text messages. He was who I was communicating with, he and Anna. But at that time, he was their front man. Now, I can also tell you that Anna, who also worked there, she was the best communicator with me. She actually reached out to me to see what they could do to keep me in the property. But I asked her at that point about Jackson, because in an email from Tanisha, Miss Williams, the property manager of Ventura, who's on this Zoom, I had asked for quite a few things. They were not given to me as a new tenant. And so it's like they're trying to basically avoid the service. You understand? So they refused to accept the documents from Eugene Young. Nelson was the person, and he drives that vehicle, I know, because he met me at the property in that vehicle.
And the tag number is here on.
And that tag number is on here from our processor server. So to say that they didn't know who it was, I'm not quite sure how accurate that is, because I know who it is. I dealt with him. Now, Anna did inform me once all of this started that Jackson, Nelson, and Kenji was no longer with the company. So I don't know what happened. It's like they kept tossing around the responsibility. I kept getting tossed around, like what's happening now with the attorneys. There have been multiple attorneys that I've seen on documents, and it keeps changing. So that is what I have to say, is that, yes, Nelson,
We serve properly.
we did serve properly, Your Honor. We did serve properly according to the Georgia law.
Okay, so one question I have, Ms. Holmes, is, and it may be that I also want to ask this question of Mr. Parnell. So procedurally, one of the reasons I asked all those questions about procedurally where the case is in front of me is that in terms of possible resolutions, right? One of the issues was Ventura Management filed a motion for reconsideration that was never actually heard because there wasn't notice of that motion for reconsideration. And so one question I have is, do you have any, were you present at the hearing on December the
6th.
date that was the date that was set for the sometime in, I think it was December the 6th or 7th, the date that was set for the motion to set aside?
Your Honor, yes, I was present, and for the record, they also stated that my attorney withdrew on December 4th. That is correct. There was a misunderstanding between he and I, but he actually was the one who texted me, and I have that here, the text message. He and I were there, and he at that point told the judge that the judge questioned, well, Mr. Anfield, did you withdraw? And he said, I did, but I take that back, and I'm here on behalf of my client. So
Okay.
I was there. I was on the Zoom. My attorney was on the Zoom.
Okay. So, Mr. Parnell, let me ask you a question. So, one thing I am looking at is trying to figure out the extent to which, given that the notices, assuming that the entry in my system of the notices having been generated is the internal evidence that the clerk uses to demonstrate notices being generated and served, like actually mailed. It does appear to me that one was served on Ms. Holmes, one was served on Ventura, one was served on Ms. Holmes's attorney, and one was not sent to you. A notice was not generated to counsel for Ventura, which was you, Brendan Parnell, who with Quirk and Quirk, who had entered an appearance on the 10th day of November when you filed your motion to set aside. So one question I have procedurally is, if the court decides that you didn't get notice of that hearing that you were entitled to, because no substantive finding was made on your motion to set aside. I mean, no court actually considered the evidence that y'all have as to why you believe the default judgment should be set aside. Procedurally, if I'm concerned about the notice to Ventura's counsel, is the appropriate answer for me to remand it to the magistrate court to deal with the motion to set aside the default? And the outcome of that may be, no, we will not set aside the default, and then you can appeal. Or yes, we will set aside the default, and then Ms. Holmes can appeal. But it seems to me that much of the evidence y'all are trying to offer is actually not appropriately before me because it wasn't considered by the magistrate court. I mean, I can look at the affidavit of service, and I've already said it leaves a little bit to be desired. But whether there's supporting evidence of no, we weren't, yes, we were, given that there was no hearing had and it was entered because of a lack of appearance, what say you on that procedural posture, Mr. Parnell?
Yeah, I was thinking about this a little bit too, Judge. It's a unique circumstance. Remand, I think, would be appropriate for the reasons you stated. This is a little different than a de novo appeal of a judgment that's been entered or a verdict that's been rendered or an adjudication that's been had in magistrate court, because it is an appeal of a procedural issue. That being said, if it would be appropriate to take the case up in a de novo status before Your Honor, we're all here and ready to do that, and it's less delay and less expense and all of that.
I understand that, but if my job as a reviewing court is to determine if the finding of the lower court was appropriate, currently the finding of the lower court that's in front of me is you didn't show up, so we're not hearing it substantively.
I would agree.
And that's, I know that there's the evidence of, there's the affidavit of service and the evidence of Mr. Young having served and the additional context that Ms. Holmes has given, and Mr. Gilmore. And I know there's an affidavit in the file, but because these are factual issues that would have been considered by the magistrate judge, and having not been considered, it does not appear to me that any substantive finding was made as to whether service was sufficient or not sufficient, such as to justify the setting aside of the default judgment.
I would agree.
And so, Ms. Holmes, so again, I don't want to condescend to you, but I do want to make sure you understand, because you are not an attorney, sort of what I'm talking about, and give you an opportunity to ask questions. So what I've been explaining to Mr. Parnell is, when I am sitting in this capacity on a case like this, my job is as a reviewing court, right? It's not my job to start over again unless it is appropriately before me on a de novo review, and then we start over again. But what I'm concerned about is that Mr. Parnell had appeared in the case effective November the 10th. And then the court and filed by filing that motion to set aside the judgment. And the court issued notices on November the 22nd, according to my system. And they issued a notice to you and a notice to your attorney and a notice to Ventura, but not a notice to Mr. Parnell, the attorney who had filed the motion. And given that lack of notice, what I think I might do, I'm not ruling that service was or wasn't valid. I think the issue is that that's an issue that should have been addressed by the magistrate court. And I think what I'm inclined to do is say that in the absence of notice to Mr. Parnell as the counsel who had filed the motion, there doesn't seem to be any question that no notice was issued and directed to him, despite the fact that he was the attorney of record who'd filed a pleading. And despite the fact that the court issued a notice to your attorney. It seems to me that the order denying the motion to set aside for failure to appear that was entered by the court on December the 7th should be reversed and remanded to the magistrate court to have an actual hearing with notice to both parties so that the magistrate court can determine the issue of service. Now, it may be that the magistrate court determines that service was appropriate, and in which case Mr. Parnell may file an appeal. It may be that the magistrate court determines that service was not appropriate, in which case you would need to determine, whether you need to secure service in some other manner or whatever. But I think that legally that's the route that I'm going to take. So I think what my ruling is going to be is I'm going to decline to reconsider the motion to set aside the judgment, right? Because that would be a de novo review of something that's not actually a part of the record. But I'm going to reverse the order denying the motion to set aside that was entered on December the 7th. And I'm going to remand the case to provide notice to the parties and have a hearing with notice to all the people, lawyers, non-lawyers, etc. And then the parties can take appropriate action at that point. Understanding that either or both parties might be unhappy with that ruling. Do you have any questions or issues that you need me to address while we are still together, Ms. Holmes, regarding what my ruling is going to be? You're muted, Ms. Holmes. Or Mr. Gilmore. There we go.
Yes, hi.
Hi. Can Mr. Gilmore speak now, or do you need me to speak?
No, it's fine to let Mr. Gilmore speak.
Okay.
Okay, ma'am. We're also here for the dispossessory that this attorney, Ventura manages bringing forth. Are you saying you're also setting that aside? Because the process service was already approved by the lower court. We already showed up in court, in person, by the way.
Yes.
And Ventura management decided not to show up. We showed up on the Zoom. Again, like you say earlier in an earlier ruling, you prefer to make a decision when people don't show up. So Ventura's way of sidestepping is to keep throwing this case around to different attorneys. And this attorney, with all due respect, is saying, I didn't get served. Well, guess what? We go into court, into the clerk's office, we file it into the record. And so the court record shows that these documents were filed, that the process server, the affidavit was filed. The lower court has already determined that the process service was according to Georgia law and it was acceptable. Yes, we hired a private process server, but that's what they do for a living. And they gave us also an affidavit when they could not serve because Ventura notoriously, if you look in the record and you even do a Google search, you see that's what they do. They avoid service. They avoid responsibilities. And so that's our position on it. This keeps getting tossed around like a football and nobody's taking responsibility, but we keep showing up. We showed up in person during COVID for this. And we're showing up on different Zooms as well. We're here. And we just like Latanya has been here to pay the rent on time every time. She's here to stand against Ventura management and the way they've been sidestepping the responsibility in this case.
And I'd also like to add, Your Honor, that I respect whatever decision you make. I just want to also add that the owners of the property who hired Ventura management reached out to me directly because they fired them. Why? Because of mismanagement of money. And I have,
I'm gonna object here. I mean, this is evidentiary. There's
okay.
Well, no, it's actually right now just argument because Ms.
Right.
Holmes is
I'm
advocating
just
for
making-
herself as an attorney. Nobody's under oath and the court's not accepting anything that's being said as evidence at this point. Go ahead,
So,
Ms. Holmes. But
my
Mr.
point-
Parnell's point is well taken that you are getting a little far afield of the issue that's in front of the court today. So
Okay, no problem. I'll save that for if we have to deal with it. But I just want to state the pattern of Ventura management. Again, unfortunately, it seems as though Mr. Parnell has been brought into a situation that, again, if you look at the history of Ventura management and this situation, there have been numerous attorneys on my email threads, in the files. And so him saying he wasn't served, technically I wasn't either, but my attorney was, because they kept sending notices to 252 West Simon where I no longer lived. So everything that they were sending, I wasn't getting it, but Attorney Joseph Ansfield was. So even though and my attorney did an address change, but he said that he doesn't know if it got read because
The problem with Joseph Anfield is he's too busy and he,
well, I understand and he's no longer in the case.
right.
The only reason that I mentioned him at all is that at the time that these notices were issued in this case, the 23 MS 180744, both parties had lawyers.
Mhm,
And
correct.
despite that, the magistrate court did not serve the lawyer for one of the parties. There's no indication that a notice was generated and sent to a lawyer for one of the parties, only only you and your attorney. And the defendant was sent a notice, but no notice went to the attorney of record.
So
And
my
that's
question,
the
I'm
only
sorry.
thing I'm
Sorry.
addressing right now. Sorry, go ahead, Ms. Holmes.
So my question to you, Judge, is if they got served, the defendant, I understand what you're saying, but at the same time, it's like, well, I didn't get served, but my attorney reached out to me. They got served. Is it not normal for them to reach out to their attorney?
It usually is, ma'am, but
Mhm.
what I'm saying is that it is also normal for the court to notify an attorney of record who's filed an entry of appearance, and that didn't happen here. Now,
And we have,
I'm sorry.
Your Honor, they're also trying to relitigate this case in front of you. They're trying to
Right,
relitigate
but
and they're not even
Mr. Gilmore, sorry.
Mhm.
So to be clear, I understand that they're trying to relitigate the case in front of me, but my ruling is that I'm not letting them, right?
Okay.
What I'm saying is that to the extent there was a motion to set aside based on an allegation of improper service, that matter has not actually been ruled upon by the court below. Instead, what has happened is that the court below denied the motion on the basis that Ventura Management did not appear. But Ventura Management's counsel of record, who had properly appeared in the case, did not receive notice of it. And so to be clear, I want to make sure, one, I'm not ruling on the issue of the underlying service because there's nothing for me to review because the underlying court has not made a ruling that that service was sufficient, number one. Number two, to Mr. Gilmore's point of the question that you asked a moment ago about, does that mean that their dispossessory whatever also is undone? So I want to be very clear that the only case in front of me today is the case of Ventura Management LLC versus Latanya Holmes, 24 CV 0000332, which is a petition for review that was seeking to review case number 23 MS 180744, which I believe was a suit filed by Ms. Holmes against Ventura Management. And I don't know the substance of what that claim was. To the extent that both you, Ms. Holmes and Mr. Gilmore, and Mr. Parnell have mentioned that there is other litigation that occurred in the magistrate court between these parties, that matter is not before the court.
Okay.
It was not appealed to me by any party, and it has not been assigned to me to take any action. And so the order that I'm going to enter is an order reversing the December 7th order denying the motion to set aside, only because notice was not given to counsel of record for Ventura Management, and ordering the magistrate court to set a hearing and provide notice to Mr. Parnell, to Ventura, and to Ms. Holmes and any attorney that you might have at this stage to have that ruling, that hearing. And then once a substantive ruling is made, if it is, if it's refiled, you know, if it's appealed, then the court will deal with it from there. Mr. Parnell, anything else you need?
Nothing further.
Okay, I'm going to enter that order. And I will, Ms. Holmes, do we have, are you in the system to receive, like, when we entered a notice, you would receive that notice by email, or do we need to mail that to you?
I haven't been receiving anything via email. I finally went to the post office and did a change of address, even though I haven't lived there forever. So I got the notice in the mail, but I would like to get the emails.
Okay.
And also, I'm not quite sure how this works. I'd like to ask, because Attorney Ansfield is still in touch. We actually spoke yesterday, and since he was a part of what we're talking about, I'd like for him to be on that because he was retained for that.
Okay, so
Your Honor, we're here for the dispossessory initially, right, on behalf of Ventura Management. And
no, sir. As I was saying, the only case that is in front of me is the case that Ms. Holmes filed against Ventura Management. To the extent that there is this other dispossessory, which I'm aware of because both of y'all have mentioned it, that is an entirely different case that carries with it a different case number that was filed by Ventura Management, and it is not before me. And so I'm making no ruling. I have no authority to make any ruling or consider any of those issues. Now, what I am going to do is I'm going to enter that order. The reason I asked Ms. Holmes, Mr. Freehoff, if you could please put your email address in your Zoom box.
Yes, we'll do that right now, Judge.
So Mr. Gilmore and Ms. Holmes, Mr. Freehoff is going to put his email address in the little Zoom box so you can see it. If you would please send him an email so that he'll have a good email address for you. What he will do is make sure that you receive service of the order that we're going to enter, so that everybody will be clear and it will go back to the magistrate court. And to the extent that you want to notify, so Mr. Ansfield L has not appeared in this case. And so he's not an attorney of record in this case. Now, he was an attorney of record in the magistrate case, but then he moved to withdraw, and I believe was allowed to withdraw. So the court is not going to be providing him with notice. You're of course free to, and if he wishes to appear on your behalf at any later time, then, you know, he knows what that process is to either file something like a substantive pleading or motion or an entry of appearance.
Okay, just to clarify, I'm sorry. I guess because he's not documented, you're saying he did let the judge in this case that we're talking about, that Mr. Parnell was not notified of. He did say, because the judge brought that to our attention, he said, Ms. Holmes, it looks as though Mr. Parnell, Mr. Ansfield did a withdrawal did he notify you? I said, yes, he did. And I said, and then the judge, I said, yes, but he also is the one who contacted me. We've reconciled our differences. And I have the text message here from him telling me there's a hearing going on.
So let me interrupt you. I'm glad to hear that Mr. Ansfield L is still responding to you and trying to assist you. All I'm saying is that he's not legally the attorney of record in this case because he never filed anything in my case. And in the underlying magistrate court case, he asked for permission to withdraw as counsel of record, and he was granted the ability to withdraw. So he is not an attorney of record in either case. That doesn't mean he's not helping you. And if he wishes to appear on your behalf, he of course knows how to do that.
Okay.
So that like I said, I'm glad he's still assisting you, but in terms of his official role
Mhm.
in this case, he does not have one.
I
Okay,
understand. Yes, ma'am.
okay.
Thank you.
Thank you both. We will, Ms. Holmes, just a reminder, Mr. Freehoff's email address is up now. It's mitchell.freehoff@fultoncountyga.gov. If you will send him that email when we enter our order, we will make sure that you receive notice of that, and we will
Okay.
go from there.
I will
And
email you right now. Thank you so much, Judge.
Thank you. Mr. Parnell?
Judge, do you need anything from me on that order, or is that something Mr. Freehoff will prepare, the court will prepare?
I'm gonna have Mr. Freehoff prepare that order. Thank
Okay,
you.
all right, just checking. Thank
Okay.
you.
Have a good
All right.
day.
You too.
You
Thank you so
too.
much.
Thank you.
Okay. Okay. So I need to take about a 2-minute break and check on the status of my criminal plea, because when I said I was going to break at 9:30, it turned out that my inmate had not been brought over from the jail. And so now maybe he's here. So I just need to check. And I will be right back with you. I thank you both for your patience. I'll be right back. Okay, so I'm gonna have to impose on your patience for just a little bit longer. I finally do have everybody in place. It's probably gonna take about 15 to 20 minutes. So what I'd like to do is just hopefully let y'all multitask and do other things and use this time more valuably than just sitting here. If we could just say, let's plan to reconvene at 10:45. It's 10:21 now. We'll reconvene at 10:45 and we will take up this matter substantively and get moving. Okay. Thank you again for your patience. I'm sorry for the delay, but I'll be back with you guys at 10:45. Okay.
Great, thank you.
Thank you. Good afternoon, or I guess technically still good morning. I'm really sorry for the delay, but I thank you again for your patience. I am ready to go ahead and get started now. And you will now have my undivided attention. Let me start by telling you that I have had a chance to read the briefing. And so I am aware, of course, that there is the preliminary issue of the motion to dismiss for both a lack of subject matter jurisdiction as well as for lack of service. So let me start by asking, since it's your motion, Ms. Radley, I would call upon you to begin. But let me start by asking you this. I definitely need you to educate me a little bit about the subject matter issue in terms of the waiver of sovereign immunity aspect. But in terms of service, I understand that there's this PO box issue, but okay. I also understand that there's at least initially a position taken by the Department of Driver Services that the only remedy available was through, I think it's Title 50, and that they, Mr. Garcia, pursued a petition for review under the new unified appellate structure. And so let me start by asking this. Are you willing to agree that service was sufficient under OCGA 5310?
No, Your Honor.
If we're proceeding under that statute?
No, Your Honor. It was never mailed to DDS. If you look at the certificate of service, which is page 5 of the petition that was filed, it indicates specifically, let me go to page 5 so I can read it specifically. It says, I certify I have this day served a copy of the document by hand delivery, email, or e-file to Department of Driver Services at a PO box. None of those 3 things can be done to a PO box, Your Honor. And DDS has never received anything.
Okay. And one question, okay. And then one question I had is, I know there's some issue about Ms. Radley about this argument that service on Mr. Wooten or Officer Wooten would be sufficient for service on the, I'm honestly not sure if it's the lower adjudicatory or if it's
Sure.
DDS, but can you address that for me, Ms. Radley?
Yes, Your Honor. That was brought up by petitioner in the reply brief, and the case that they used was Schumann. Your Honor, if you read Schumann, the underlying agency, so the agency that was the lower adjudicatory or whatnot, was represented by attorneys. And therefore, they went ahead and served the attorneys that were already representing the agency with the notice that they were appealing to the Superior Court. And so I think if our office had been representing Driver Services in that ALS hearing, there was an attorney there representing the agency, then Schumann would apply. But this isn't an attorney that's representing them. It's the officer that's set up statutorily under 40-5-67.1 to be sort of the witness and the person who serves the notice upon Mr. Garcia, upon the petitioner, that, hey, your license is suspended. It's a statutory scheme that's set up. In no way, shape, or form could Noah Wooten come into court and represent the Department of Driver Services here in the Superior Court before Your Honor.
Okay.
I mean, that's just...
Well, I mean, I don't necessarily disagree with you that I was surprised to see an argument that an officer, even under the statutory scheme where they're empowered to make service in some way, is somehow also empowered to receive service or receive notice. But in the larger scheme of things, and that's why this might be where we transition into the subject matter jurisdiction and the sovereign immunity issue, but one of the reasons that the 5310 unified appellate structure was adopted by the legislature is because of all of the ridiculous procedural technicalities that oftentimes prohibited or inhibited the ability of the actual substantive issue to get before the court. in this instance, for example, for Mr. Garcia to have another court consider the ruling of the lower court. And so one question I have is that because that was the purpose of 5310, assuming we're traveling under that, why wouldn't any of this just be an amendable defect that could be fixed by, say, an acknowledgement of service or proper hand delivery on the DDS?
Well, for service, I certainly think that if Your Honor feels that 531 applies, like that statutory scheme applies, then yes, she could certainly have served us. Mr. Garcia could have served DDS, but DDS still at this point has literally never been served by that.
Right. No, but that's my question isn't all of that though an amendable defect that instead of granting a dismissal, I should allow potentially procedurally Ms. Golding an opportunity to secure appropriate service?
Well, the question would be whether or not then Georgia DOT v. White, which is the 367 Georgia Appeals 65 that I cited, where that case held that using the wrong statutory scheme, that sovereign immunity would bar the suit for them to continue. So, and I think the problem would be that because it's gone under the wrong, if the case is dismissed because sovereign immunity applies as a bar, then I don't know that you can amend because you've gone under the wrong statute. It's like if you, under the old appellate rules, if you did a direct appeal instead of doing it as a petition to appeal to the Court of Appeals, and you got it wrong, you were out of luck. You couldn't go back and amend and say, hey, I meant to do this as an application for a discretionary appeal, and I direct appealed by accident, and so I can go back and amend my notice of appeal. It doesn't work that way. You have to proceed under the proper statutory authority to present the appeal to the Superior Court.
So if Ms. Radley, Ms. Golding, talk me through the process that DDS believes that Mr. Garcia should have followed under Title 50.
So if you look at 48-5 67.1, it specifically says that you have to appeal under the APA, which is 5013 at sequence. And so normally what is done is, most of what was done is you file the notice of appeal and you file it in the Superior Court, and you can file it in Fulton. It can actually be filed in the Superior Court where he resides. So if he resided in another county, he could file it there as well.
Yeah, I recently was involved in the litigation of that issue about APA.
Yes.
And
then I think service by mail is allowable. The statute is silent in the APA as to how service is done, but there has been subsequent case law that service by mail is appropriate. But when you're talking about a state agency, Your Honor, I actually kind of felt it interesting. I was kind of glad that we went after that service case that you addressed earlier, because service still has to be done. We're talking about a state agency. We're not talking about a person where you know where they're located and what they look like. State agencies, all of the state agencies, if you look at their rules, dictate how service is to be done, where that service is to be served, and how it's to be served. And so I did include that in the brief, that under DDS's rules, that when it's under the APA, you can serve by mail, and that you're supposed to mail it to the PO Box, Attention Legal Services, and that you're also supposed to send a copy to the Attorney General's office, because we're the only ones that can represent the agency in Superior Court, and that's pursuant to statute and the Constitution. Whereas if it is a regular lawsuit, or it went under 40-5-66, which I know Your Honor's aware, some DDS appeals are under that and not under the ALS scheme, then because it has to be against the commissioner under 40-5-66, then it needs to be done either by, I think, certified mail or by personal service. And then that involves their Eastview Parkway address in Conyers. And again, they asked that a copy be sent to the Attorney General's office. So I'm not saying that mail isn't sufficient. I'm saying that, first of all, it wasn't mailed.
Get mail, right?
We didn't get anything. Her certificate of service doesn't say that we got anything. Her certificate of service, which is how she certified it was sent, was by hand delivery, email, or e-file. And DDS wasn't on the e-file. DDS wasn't added to the e-file until OSA, who she also served a copy to, added Chris Correa.
The notice of filing when they did the court record.
Exactly, Your Honor. So there has been no service at this point
Okay.
on DDS of any notice of hearing. In fact, we didn't find out about it until we got copies from OSA. And then because OSA had added us as a service contact, when the court did its notice of hearing, we received a copy because OSA had added us in there.
Okay. So going back for a moment, and then I'm gonna switch over to Ms. Golding and hear from her on these issues. Assuming that the unified appellate procedure is an avenue that can be used, or a procedure that can be used by Mr. Garcia to request relief for a moment. That I believe is the service issue is an amendable defect that can be fixed. I understand that there's an issue of whether that is an appropriate procedure for her to be following at all.
I agree, Your Honor.
And so let's address a little more clearly this issue of why you believe that procedure had to be followed. I understand you've pointed me to the so this is not the first time I've run into an issue where, despite the efforts of the legislature to speak with one voice and really be clear, this is the second time in the span of 2 weeks that I've run into issues where there was a previously existing statutory structure for people to appeal different types of things that the state would do. For like in the other cases that I'm dealing with, it has to do with students who've been disciplined and have appealed. There was a procedure for that, and now there's an argument that no, that's not the right procedure anymore, or maybe that is the right procedure anymore, and how does it change how it gets to the court and what the court should decide? So address for me one more time that issue, and then speak specifically to this issue of, I mean, I think I understood your briefing to be that because she did not follow the APA, that there's no waiver of sovereign immunity, and therefore the case has to be dismissed.
That's correct, Your Honor.
Okay. So tell me where and why you believe that the new unified appellate structure either specifically excluded, did not address, or intended not to apply to these types of appeals.
Yes, Your Honor. So if you look, first of all, there is that overarching idea that a specific statute would trump a non-specific statute. So that is, let me find that case.
Well, don't worry about it. I'm very familiar with the general rules of statutory interpretation. Right. Yes, that is a correct statement of law. So.
Right. Okay. So
and I know it's in your brief as well. So
yes. So if you look at 40-5-67.1, it specifically provides that appeals from the ALS hearings are to be pursuant to Chapter 13 of Title 50. So that is a specific statute. So that is the statutory scheme that is to be applied in ALS appeals. And if you look further, I cited them, I think I put them in a footnote, Your Honor, but after the legislature enacted the 531 et sequence of the Appellate Practice Act, they went back and amended other statutes to specifically say 5-3-1 applies. And in fact, there's one statute where there are two different types of appeals within the same statute. And they said 5-3-1 applies to this and 5013 applies to this. And it's in, I'm trying to find because I made a list of them in the footnote. I didn't want to put them in the body just because they were long, but it is in the, let's see. Yes. So in contrast, General Assembly has specifically provided that judicial review of certain other agency decisions is pursuant to the Appellate Practice Act, as opposed to the APA 3-2-35E, 10-44-22B, 12-3-194.1C, 12-3-236.1B, 22-3-44, and 31-6-40 44.1B all provide that a review of a decision or appeal shall be governed by Chapter 3 of Title 5 of the Georgia Code. And in fact, that last one, the 31-6-44.1B, provides for review under both schemes, but under different sets of circumstances.
Okay.
And so the argument would be, one, there's the statutory construction argument that a more specific statute would trump a less specific. And two, the fact that if the legislature meant for all of these administrative appeals to fall under 5-3-1, then why would they go back and amend and specifically put in there with regard to these sections that this is what applies? And why would they differentiate in 31-6-44.1 then under this set of circumstances it's this way, and under this set of circumstances it's another way? There would be no reason for the legislature to have done that if that was its intention. And so that's where the argument is coming from, Your Honor.
Okay. One last question, and then I'm going to call on Ms. Golding, and that is not to sound like a broken record, but let's say that the court is persuaded that in fact, Mr. Garcia should have pursued this relief under the Administrative Procedures Act. Given that what is it that Mr. Garcia failed to do other than saying, I am hereby appealing under APA? Is it that he was supposed to file some sort of appeal with OSA and get yet another person to review, given that he already had a substantive review? And the reason I ask all of that is this not also something that could be amended in a timely pleading that presumably we have before the court, to allow the court to reach out and actually do what the legislature by any standard wanted the court to do, which was to consider the substantive issue and determine if the lower court was right or wrong?
Your Honor, this is an issue of first impression. So
I hate that sentence.
Yeah, I know, me too. Believe me, after 24 years, I still hate using it. So the only thing I can point the court to is that Georgia DOT v. White, which is actually the reverse situation, where the Court of Appeals held that the appeal should have been pursuant to the APA, and instead they presented the appeal under a different statutory scheme. And because they presented under the wrong statutory scheme, that, it was subject to sovereign immunity and dismissal, and it should have been dismissed. So all I can say is this is sort of the converse here, where it was presented pursuant to the wrong thing, and it should have been under the APA. And so we have, in a similar vein, moved for a dismissal, saying that you've done it under the wrong statutory scheme, and therefore sovereign immunity bars your claim.
Understood. Ms. Golding.
Yes, Judge. Good morning.
Thank you for your patience.
No problem. Oh, so
yeah,
you have
please go
specific
ahead.
questions or? Okay, so as far as the notice goes, so they were served via the PO box, and that was the same method that we also used to request the hearing and also to send payment for the hearing. And then the reason that I mentioned Officer Wooten was because the statute states 50-1317 that it should be on each party of record. And so because the Attorney General was not a party of record, or the General Counsel of DDS was not a party of record, then they were not considered part of the record until.
Yeah, so forgive me for interrupting. Two things. Number one, it's speaking of the rules of statutory interpretation, it's that lovely one about how you have to read the statutes in paramateria. There's another statute that says that when you sue a state agency, you have to notify the AG's office. I think they have to get 5 days notice or waive that notice. And now that's not the same, Ms. Golding, to your point, as service on the AG's office. That's not the same. I agree with you. One question I do have, though, and I want to go back for a moment, is you mentioned that that DDS was served through the same method for these other subsequent issues. And so what Ms. Radley has pointed out is that, so let me ask this better. Is the issue that you did serve it by mail, but your certificate is wrong because your certificate doesn't say you served it by mail. It says you served it by hand delivery, email, or e-file, which is what Ms. Radley has pointed out? Or is it that you, I guess that's not my, you said we did serve it. So do you mean you mailed it and your certificate's just wrong? Is that your position?
Yes, Judge. So I suppose that the certificate is just wrong, but we did mail it. And so I did want to turn the court's attention to also the notice of this hearing. So your actual staff attorney, Mr. Freehoff, when he sent out the notice of the hearing, he sent it to Officer Wooten and as well as DDS to their PO box. The Attorney General is not listed on there, neither is the General Counsel of DDS. And so he said that it was also e-filed. And so I would say that goes to my point that he served the parties of record.
Well, so the issue is, I think, Ms. Golding, where we're disconnecting is, I don't think there's any, I don't think at the outset that you were necessarily obligated to serve the Attorney General. I think the issue that we're having is you were required to serve the DDS, and service is allowed by mail, but the DDS's preliminary argument is you can't hand deliver something to a PO box, and you can't e-file or email, which e-file, all it does is generate an email to a registered an email address. You can't do any of those three things to a PO box. And so I think that the first issue we need to address is it your belief that in your office this was mailed to that post office box?
Yes, Judge.
Okay.
And then I also wanted to turn the court's attention to Schuman, in which they basically set out these things about petitioner versus plaintiff, and that the service of process generally denotes an element of the commencement of an action. And then they further went on to reason that the department was actually not being sued as a defendant and that they were not actually a defendant in the party. And so as far as service goes, that basically connotates the beginning of an action as opposed to a continuance of an action that Schuman was actually responding to, which was about a child abuse registry. And he didn't want to be put on the child abuse registry. And the court basically said that the department tried to dismiss the case based on sovereign immunity. And the court ruled that the department was actually acting in more of a quasi-judicial capacity and not as a defendant. And so sovereign immunity was barred. And then I know that the state is relying on White, and I feel White is not really applicable to this case. Like the state said, I believe it is an issue of first impression because no one could perfectly find a Department of Driver Services case that perfectly tracked the issue. But in White, it was actually about a commercial driveway, and the reason that 50-13-19 didn't apply to the case is because under that statutory scheme, the petitioner was not entitled to a hearing. And so the court has said, reading these sections in concert, a claimant is entitled to judicial review on an agency decision only if the agency is mandated by law to provide an opportunity for a hearing. So because the statutory scheme that White relied on did not provide an opportunity for a hearing, the court said that 50-13-19 didn't even apply to his case. And so contested cases under APA didn't apply to his case because he did not need an opportunity for a hearing. Whereas in this case, it is a contested case because Mr. Garcia was provided an opportunity for a hearing. And so it does fall under, I think, both 50-13-19 as well as 5-3-1. And I think they run parallel as opposed to contradicting each other. But even if they did contradict, I think that 5-3-1 controls because it's preemptive. And I think that's the whole reason for the General Assembly to even make a uniformed way for petitioners to file a petition for review, because like you stated, it's just become complex procedural issues about different things.
Okay. Okay. So one of the things I have mentioned several times to Ms. Radley is that is to wonder out loud if if the answer here is to have you attempt to amend your pleading to or to amend it substantively or to amend it to demonstrate service. Because while I suspect that in practically speaking in real life, somebody mailed a notice to the DDS at that PO box. That certificate of service, which is one of those things that everybody forgets about, and it's just a form in everybody's computer. It does not say that service was made by mail. And so on its face, it does not indicate that service has been made on the DDS, even though I don't doubt you, Ms. Golding, when you say you believe that it is your office's procedures for that to have been mailed. But if we are proceeding under OCGA, under the Unified Appellate Practice Act, right? It's clearly an amendable defect for you to properly secure service. And I'm not, it may be something as simple as providing a proper certificate of service, or actually serving further in a manner that would be appropriate to serve. I don't know what that is because I haven't looked at it. A manner that would be appropriate to serve the DDS. And I'm not suggesting by saying that it's not the PO box, but because there's this discussion about it, what I am suggesting is there's at least some dispute that the PO box is an appropriate way to serve. But even if it is an appropriate way to serve, it seems clear to me that even if you actually got notice into the hands of the DDS, that your certificate of service is lacking in its facial demonstration of service in a manner that is allowed. And so I think you're at a minimum, you have to reserve. You're going to have to reserve and amend your pleading to demonstrate service under 531. Now, that also leads us back to this issue of whether or not the specific statutory structure that previously applied to DDS also is preemptive, or if it still in some way applies. And I think what I'm hearing, knowing that you two probably know much more about both of those statutory structures than I do currently, what I think I'm hearing is that while the procedures are different, and the substantive outcome in terms of the clear waiver of sovereign immunity if one statute is followed, and the not so clear waiver of sovereign immunity, or the not waiver of sovereign immunity if the other procedure is followed. Ultimately, what I think I understand is that this is all a matter of procedure, and that if the right statute is invoked, that the court would be able to reach out and address the substance of the case. And I don't know the answer to that part of the question. I'd like to spend some more time with the case law that's been cited by Ms. Radley and by Ms. Golding to determine, but I think here's what I think I'm going to do. I'm gonna take this under advisement. I am going to advise you guys in the next few days. Hopefully today is Thursday, hopefully by Monday, of what my ruling is going to be, what I want to find, right? If I'm right and confirmed to my satisfaction that it's a procedural structural issue, right, that gets us past the substantive issue of sovereign immunity, then what I may do is enter an order that gives the petitioner 10 days to file an amended pleading of some sort, whatever amended pleading you deem to be appropriate, and then the court would deal with it from there, giving them an opportunity to determine if there are other ways that they need to proceed. Now, if my research tells me that there is more at stake than simply a recitation of procedure that results in that waiver of sovereign immunity, but if there is more substantively at stake that has not been addressed here, then ultimately what I may do is say that the case should have proceeded under the statutory structure that traditionally applied to DDS, and that without it, there has not been a waiver of sovereign immunity, and therefore the case should be dismissed. That the question I have to answer for myself is what is the procedural and substantive right distinction between those two statutory structures? And once I do, I will be able to give you an answer. Either way, right? One answer is I'm going to dismiss, and then you can take whatever action you believe you should take on behalf of your client, Ms. Golding. The other option is I may enter an order requiring you to amend. And presuming you amend, I don't know what action Ms. Radley may take, but I would expect that we would then have another hearing where we would maybe preliminarily deal with another motion to dismiss. But we would expect to look at the substance a little more directly. Questions, concerns, thoughts about that general outline of plan? Ms. Golding?
Not necessarily, Judge, but I also would like you to just note that once the agency did transmit the record to the reviewing court, that does also go to service. And so basically, that was also an issue in Schumann, that if they didn't receive notice, that they wouldn't have transmitted the record.
Right. I know you're right. And I don't disagree with you. But one of the things that I am called on to deal with frequently is that really important distinction between actual notice and proper service, right? And so I don't think there's any dispute, given that Ms. Radley has appeared and that they have filed a motion to dismiss. There's really no dispute that DDS received notice. But they are entitled to proper legal service under whatever statute. And that's the thing that it's my job to make sure those T's are crossed and those I's are dotted. Even on the lower, I mean, obviously, right, if you're traveling under 531, there's a lower service standard, right? You can just mail it to them. Whereas if you're under a different statutory structure, under the old certiorari scheme, there are personal service requirements. But even under, excuse me, even under the lower service requirements for 531, that T isn't crossed, that I isn't dotted. Again, I don't question that DDS became aware of this lawsuit. And honestly, I probably don't even question that your office mailed out this proceeding, which would satisfy 531 and to that PO box, assuming that PO box is an appropriate address for service. The issue is that your certificate of service doesn't say you mailed it. And so even if you did mail it, there's no actual certificate proving that you did so because the certificate doesn't say you mailed it. And so again, that's my job, especially for service issues, to make sure that those T's are crossed and those I's are dotted. Service is not a game, and we're not, right. And Ms. Radley knows that because she filed a special notice appearance and appeared because she got notice of it. But that doesn't mean that they're not entitled to appropriate, proper service and to make sure that the file is documented in the correct way. So that's what I'm going to do. My goal is on Monday to send you guys an email that will say, here's what my ruling is going to be. If it is a ruling that I'm going to dismiss the case, then I'm going to ask Ms. Radley to draft a proposed order for me. If it is a ruling that I'm going to require that I'm going to give Mr. Garcia 10 days to file an amended pleading and to secure appropriate service as in whatever manner is required by statute, then I will probably ask Ms. Golding to provide me with a proposed order to that effect. But my goal is to do that Monday so that we can still keep this moving along, because I understand that, Mr. Garcia has a vested interest in having his day in court regarding his ability to, the circumstances under which he had his driver's license taken away. Okay?
Yes, Judge.
Anything else you need me to address while we are together before I will email you guys on Monday?
No, you're right.
Nothing further.
Okay, excellent. Thank you again for your patience. I'm sorry that it took so long, but I'm multitasking today, but I do appreciate your patience and your attention, and I will be in touch on Monday. Okay.